So good morning, everyone. Welcome to the 2026 Herald Long Island Business Summit. My name is Joseph Trotti. I am a partner at Vishnick, McGovern, Milizio, one of the sponsors for today. And from what I'm hearing, it's one of the first ever Long Island Business Summits. So thank you to the Herald for putting it on and for all of the sponsors who made today possible. So our first presentation is The Future is Now, Protecting Your Legacy and Your Wealth. It is something that my partner, Sabbagh, has been doing basically his entire career. He's going to give a presentation on it. It's a short program, so I think we're going to keep it informal. You can ask questions whenever you want, and we'll just take it from there. So again, thank you everyone for appearing. Mars, floor is yours.
Thank you, Joe. So we're talking about wealth preservation today, and we're not going to get very detailed in terms of solutions, but we do want to talk about what you need to think about when it comes to wealth preservation and estate planning. I meet with a lot of very successful people in my practice every day. And what I find with most of these successful people are they're optimists, right? They know how to grow profits. They know how to build their businesses, and that's what makes them successful, that optimism. But there's a downside to that. And the downside is that those same people do not like to think about what can go wrong. I know a lot of people who, and it's always these same people that come over to me and say, we need to speak about a will, we need to speak about a trust, and never get around to it. These are people who they don't want to think about death. They don't want to think about disability, and they certainly don't want to think about failure. But nevertheless, these are all things that we need to plan for. So let's just talk about some of the things that we need to be thinking about when we talk about wealth transfer planning and wealth planning in general and prevention of loss of funds. Let's start with the estate tax. So we have some good news on the estate tax. We now have a permanent exemption, federal exemption of $15 million, meaning that each individual can pass on up to $15 million in assets to the next generation or to their loved ones without paying a federal estate tax. Spouses with proper planning can transfer up to $30 million. Now, the New York State tax is a little bit different. It caps out at $7,350,000, and it has something called the estate tax cliff, which basically says that once you go over that $7,350,000, you're going to be taxed on the whole thing. But just in general, with these high exemptions, most people are no longer going to pay an estate tax. Now, this $15 million federal exemption was made permanent. Nothing's permanent in Washington, but for now, that's what we're working with. So because of that, there's been a paradigm shift in estate planning. We're no longer talking so much about estate tax as we did when I started planning. We were at a $600,000 federal exemption, and it was always the same thing. You get things out of your estate, get down to the next generation, get down to the next generation. With these higher exemptions, we're very often talking about the opposite. Sometimes a lot of people in 2012 were getting assets out of their name, and a lot of those people are moving things back into their name, and there's a reason for that. There's something called the step up in basis, right? It's a trade-off. When assets are in your estate, those assets can get taxed if you're over the exemption, but there's something called a step up in basis. Now, and this is for purposes of capital gains tax. If you're not familiar with capital gains tax, basically the simplest form, when you buy an asset and sell it years later for more money, you're going to pay a capital gains tax on the difference. So if you have an asset that went from $1 million to $3 million, that $2 million is going to get taxed capital gains tax. However, when you inherit assets, you're not going to pay that capital gains tax because you get a new basis. Whatever it is at death, if you sell at that value, you're not paying tax. So therefore, we have this paradigm shift in planning, and sometimes we are doing what's called upstream planning, right? We're moving things up a generation because I might have a parent who has a very small estate, but I have this asset that has this huge growth, and I can get it into the parent's estate and down maybe to my children without paying capital gains tax, or even to myself in some case, to my spouse, what have you. So there's really some great opportunities there. There's other things that we think about in terms of there's all kinds of trusts that can be used for income tax planning purposes. So these are things that need to be discussed with your attorney, your accountant, your financial planner to see what's out there. So that's the estate tax. Let's move on to disability, right? What happens if you all of a sudden were in an accident or some kind of catastrophe where you cannot handle things for yourself? There are certain things that everybody should have in place. Power of attorney to deal with financial assets, to sign checks, to sign business agreements, to run your business. And then there's the healthcare proxy that everyone should have so that there's someone there to make healthcare decisions. Now, on a business end, we want to make sure that all the business documents are in place. So things like shareholders agreements and LLC operating agreements, bylaws, these are all important employment agreements. These are all the things that must be in place to ensure that there's this continuity in the event of a disability. Now let's talk about planning for lawsuits. The big concern when we're talking about planning for lawsuits and dealing with business assets is what I call the deadly sin, which is commingling of assets, commingling of the business with your personal assets. So here we want to look at making sure, just like I talked about before with the contracts being in place, your shareholders agreements being in place, your operating agreements being in place, to control how things are handled. We want to have those documents in place, and we want to make sure that they're followed. So often, we have people coming into our office with documents that are in place and their tax returns don't match. We have the legal documents saying one thing in terms of the percentage ownerships and something else completely is on the tax returns. We have things in there as loans, but no loan documents. All these documents must be in place and everything should match up. Because if they don't, you have you have actually three issues. First of all, tax issues. If you were ever audited, all these things are going to be looked at. And the failure to have these things match up will very often cause an auditor to question the whole thing, and everyone will end up with a lot of really negative situations. Also, if you ever have a lawsuit against the business, if you if you don't have your documents in place, and if you don't have your tax returns matching, in a lawsuit, a judge is going to look at that and is going to say, wait a minute, I can't tell the difference between your personal accounts and your business accounts. You have credit cards that are being used for both. You're paying your personal mortgage out of your business account. And therefore, I'm going to do something called pierce the corporate veil. I'm going to look at this and I'm going to say, you know what? This is all BS. We're going to attach your personal assets, your home, your personal accounts, and we're going to say, you know what? There's no difference here. You didn't keep them separate, and therefore, we're going to treat it all as one thing. And therefore, you have some serious issues in terms of the personal liability that can be imposed because of the failure to properly plan and to properly keep your records straight and keep everything and have your business documents match all your tax documents.
So I wanted to ask you about, as far as business documents. I do matrimonial law. In fact, one of my clients is here, and we have this commingling document as well. And so if you commingle documents, assets that were previously separate can become marital. So you're saying if you're commingling here, you as a defendant, your personal assets could be brought into a lawsuit in the event of a judgment? Is that what you're saying?
That's exactly what I'm saying.
And we were talking about before about disability and new laws with $15 million worth of exemptions. Are trusts still the way to go to avoid wills and probate and some of the other things that people have?
So it's interesting. I have people coming in all the time saying, I need a trust, but they don't know why they need a trust. And there's so many different reasons to create trusts. And there's different kinds of trusts. There's revocable trusts, there's irrevocable trusts. And really, I like to focus on what are we trying to accomplish for you, and then determine, do you need a trust, and what kind of trust do you need? Do you need a revocable trust? Do you need an irrevocable trust? And that will all depend on what we're trying to accomplish. In terms of creditor protection, very often we will always be dealing with irrevocable trusts. But trusts are not the only way to protect assets. There are other things that we look at, such as title to assets and how they're titled, and making sure they're properly titled. Life insurance, there's all different types of planning that you can do in terms of getting assets protected for that purpose. In terms of taxes, we still need to do our planning. When I talked about the $15 million exemption, the $30 million exemption, and having two spouses get the full benefit of the $30 million exemption, we still need to do our planning. So we need to properly have our will designed properly with credit shelter provisions, and we still need trusts in place. More and more we're doing revocable trusts these days because the courts fall behind in terms of processing wills. So in order to protect people's estates, we're putting things in trust, because what that does is, let's say I have a volatile market at the person's death. With a will, if it's stuck in court and it hasn't been probated yet, we have situations where assets can be dropping in value and you can't do anything about it because the court hasn't processed the will yet. And you would think that they would put something in place temporarily, and there are provisions for temporary appointments to allow for people to take control of a person's estate after death. But the courts don't care. That volatility is not a good reason for appointing somebody. So therefore, we're seeing more and more that people want to do revocable trust, because what happens with a revocable trust is it is effective immediate upon death. The person who's the trustee can take control and start to deal with business assets, deal with all kinds of any contractual, if there's a sale, they continue the sale without having to wait for court appointment in order to do that.
And one last question, then I'll open up to the floor. We always have these questions of clients who don't want to give away all of their rights, and they feel like if they sign away a trust, irrevocable trust, they no longer have control and they no longer have possession. So what are the arguments on that? Right.
So in terms of a revocable trust, you're still retaining control. And control is always an issue for my clients. They're always concerned about control. And all these trusts, and when we set up family limited partnerships, family LLCs, we always have our clients that are have these control concerns. They're not always worried about giving up the asset itself. Very often they're just worried that I'm no longer in control. Now my children are going to control everything. So with a revocable trust, you're not really giving up control because you remain on as the trustee. When you're dealing with irrevocable trust, yes, typically, and usually this is for tax planning purposes or for credit protection purposes that you're setting up an irrevocable trust, yes, you're usually giving up control of the trust. but not necessarily control of the business, because we structure things in a manner to ensure that the person who's doing the planning can still control, using family partnerships, using family LLCs, and other mechanisms to separate control from the beneficial interest in the asset. Okay. Should we open up for questions, or? Any questions? Rich? That's correct. In the past, we were always trying to move things down the next generation, right? It was better to get it down the next generation and avoid the estate tax, because the estate tax was, the federal estate tax was 40%. You had New York on top of that, and we were working with very low exemptions. It went from $600,000 to then $1 million, then $2 million, then it went to $5 million, and now $10 million, now $15 million. But over the years, historically, it was always better to get it down to the next generation. Now, when we plan, we want to do it in a way where it's, even if we're giving it away, we're still holding on to some ties to that property, so we get that step in basis. Now, it depends. I mean, if I'm dealing with someone with, $100 million in assets, we're dealing differently, right? But when dealing with your middle level client, yeah, it's usually better to preserve that step up in basis. Yes? You're a corporation. Right. So, corporations do have that creditor protection. Can you separate control and do all these things with a corporation the way you can with an LLC? If it's an S Corp, so the interesting thing with S Corps is that you can't have different levels of ownership of an S Corp. You can't have different classifications, but you can have voting and non-voting interests. So a lot of times what we're doing with an S Corp is dividing up the voting and non-voting interests, and maybe giving away non-voting interests and retaining control that way. Giving away the non-controlling interest, right?
Was your question about the difference or the difference in protections for the two?
Well, it was because everything that was mentioned was along the lines of the LLC. So I was saying to myself, does that apply to me?
So you have an LLC already in place. I mean, you have a corporation already in place, right? Very often what we're doing in planning is we're creating these new entities. And typically, very often, these newer entities are being done as in family partnerships or as LLCs. But if you have a corporation in place, there's still planning that can be done with the existing corporation. Great question. So we always have the concern about the outlaws, right? There's lots of things that can be done, but a lot of times when we're doing planning, we're setting up trusts that are going to be ongoing, and those ongoing trusts can be designed so that the child still has control over the assets, but the assets are being kept separate from the spouse's assets, using these ongoing trusts. And doing that will protect the assets from divorce and even death, and ensuring that when you give assets to your child, it will eventually get to your grandchild and not the spouse, who's then going to get remarried and give it to their new spouse, right? So.
One of that's 11 is already in a serious relationship? The 8-year-old, yeah. It's always the second one. Any other questions? Yes.
Yeah, sometimes that is the best thing to do, is just have an outside party. But I would tell you, my experience is that it's best to be upfront, right? It's good to have family meetings and tell the family what's going on, because what happens universally is that when somebody dies and this big surprise that this person's getting this thing and the other child's getting something else, and things aren't being done equally, all of a sudden the people start pointing fingers, and it's my sister or my brother who convinced and dragged them to the lawyer and got them to do this, and that's why. So the surprise element is the one thing that I think causes more animosity and more lawsuits after death. So it's really important to be upfront about these things. Another thing that comes up that's very often an issue in families is we have businesses where we have one child in the business and the rest of the children are not in the business, and trying to balance that. You know, how do we balance that, especially if the business is a huge part of what we have to give away? So there are things that can be done there, and sometimes you are going to give parts of the business and maybe non-voting interests to the children who are not participating, or having some kind of employment agreements with the participating child, options to buy. There are life insurance is sometimes used to replace and provide for the child who's not getting an interest in the business, or dealing with other assets like real estate. But then let's say you have real estate that is where the business is operating out of the real estate. Here's what the documentation comes in again, right? We want to make sure that we have a fair lease so that the business is paying fair rent, and then when the person dies, the children who are getting the real estate are going to get a fair rent from the child who's operating the business. So these are all things, but again, our purpose today is just to think about these things and know what types of things should be brought up when you're sitting with your estate planner, with your attorney, your accountant, your financial planner, and to bring up these concerns. Because they're all important, and sometimes if you don't bring it up, nobody's going to address it. Good. Thank you.